Hello everyone, welcome back to Analyst. I'm the Ram and Ravi. Today is 28th of November 2023 and here we will be discussing two very important articles taken from the newspaper The Hindu and Indian Express. The topics are the restructuring of the Supreme Court of India. Here we will be discussing why such restructuring is required, what is the need of it, and why such need has arisen. We will get to know various constitutional provision that is relevant for our prelims as well as mains point of view. In the next article, we will be discussing the workers' death related to work-related hazards and various observations made by International Labour Organization. What are the conventions of ILO regarding labors and other labor standards? We will get to know what is the stand of India and what are the requirements of related to such kind of incident that is currently happening, as the most recent one is the Uttar Kashi tunnel incident. Now come to the first article, that is restructuring of the Supreme Court. Here we will get to know that recently the appellate matters in the Supreme Court has increasing. Okay, we know that Supreme Court is most mandated to deal with the constitutional matters, constitutional issues, but the instances has arisen that appellate matters have overtaken the constitutional matter. This is important for GS paper 2. Here the syllabus mentions the structure, organization and functioning of the judiciary. Now come and discuss this article in depth. What is the need of such restructuring? As we all know that there are different kind of issues marked by the judiciary. The most important one is the overburden. They are overburdened by the cases. Why they are overburdened by such cases? Because all judiciary from lower to the higher level of judiciary are facing the issue of infrastructure issues. Okay, and the ratio of the judges compared to the cases are also less. Similarly, the growing litigations, the frivolous litigation through various means, particularly the PILs, are also rising, and the tendency of the advocates for getting different hearing dates and delaying the justice delivery system. These all are leading for pendency of the cases. Now come to this topic, the restructuring of the Supreme Court. Okay, here Supreme Court is overburdened by pendency of the cases. If we see the figure, at present 79,813 cases are pending before the 34 judges of the Supreme Court of India. And if we see the disposal of the cases, then on and around 8 to 10 decisions are made by the constitutional benches comprising 5 or more judges. If we see the same figure in 2022, it was very dismal. Only 4 decisions were made by the constitutional benches out of 1263 decisions. This shows that the Supreme Court has become more or less a just court of appeal. That is the reason there is a growing demand for restructuring of the structure of the Supreme Court. Now we will get to know why they are such overburdened. We know that Supreme Court hears the matters between the center and state and between different states. It also hears the matters coming from the appeal on various issues, be it constitutional matter, civil matter and criminal matters. It also rules and provides legal and factual advice to the President of India under Article 143 of the Constitution. It also hears the matters of the petition by any person who feels that his or her fundamental rights are being violated through various means. And as we know that there is a growing tendency of petition through public interest litigation, PIL, for frivolous purpose. Okay, so these are also increasing the pendency of the cases before the Supreme Court of India. As we know that this article deals with the restructuring of the Supreme Court of India. Now it is high time to understand what is the present structure of the Supreme Court of India. Now let's deal the present structure. what is the present status of the Supreme Court? The present Supreme Court was established under Article 124 of the Constitution on January 28 of 1950 after the commencement of the Constitution. Under Article 130 provides for there is the primary seat shall be at Delhi, although the Chief Justice of India can locate the seat at different location on the prior approval of the President. Originally, there were 8 judges including the Chief Justice of India. Now, these numbers of the Supreme Court has been increased with the increasing burden of the cases with time by the Parliament for the 6 times. If we see that earlier it was 8 in 1950 that were raised to 11 in 1956, 40 in 1960, 18 in 1978, 26 in 1986, 31 in 2009 and 34 in 2019. So currently Supreme Court has 34 judges including the Chief Justice of India. Now come to the functioning of the Supreme Court. Originally, if we see under the Constitution, Supreme Court has 3 jurisdictions. The first one is the original jurisdiction, then appellate jurisdiction and advisory jurisdiction. Supreme Court hears matter under these 3 major jurisdictions. Under original jurisdiction, Supreme Court hears the matter or disputes related to centers and state and between two or more different states. Under appellate jurisdiction, it hears the appeal arising from various high courts, and it also hears the appeal through special leave petition that a Supreme Court can hear the matter pending before any court or any tribunal within the territory of India. Under advisory jurisdiction, Supreme Court tender advices when a president under Article 143 of the Constitution seek the opinion on urgent public importance if that importance has a question, there is a substantial question of law or fact, or if is there any dispute arising from any pre-constitutional treaty, agreement or any instrument. So under this, the Supreme Court hears the matter. So broadly, if we see that Supreme Court basically serves as a constitutional court and the court of appeal. The court sits in benches of varying sizes. These sizes are being determined by the registry on the direction of the Honorable Chief Justice of India, who is also the master of roster of the Supreme Court. Under Article 145 subclause 3, there is a provision of constitution of constitutional benches. Okay, the constitutional benches has minimum 5 judges. So time and again, these constitutional benches has been constituted of either 5 judges, 7 judges, 9 judges, 11 judges, up to 13 judges. But as per the pendency of the cases, these judges were raised to 9 only. In Keswanan Bharti case earlier in 1973, the constitutional bench comprises 13 judges. Before that, in Golaknath case, the number of judges were 11 in constitutional benches. But as the growing number of appellate cases, the formation of such constitutional benches are now being decreased. These constitutional benches are usually framed if any case or any matter pertains to substantial question of law, or if there any requirement of interpretation of the Constitution, or if for hearing any references under Article 143, that is a kind of opinions, if President is seeking any opinion from the Supreme Court of India, in that case also there is the need of constitutional bench. If we see the present functioning, typically in Supreme Court, cases are being heard by the division benches. Division benches means it has 2 judges, and full benches means it has 3 judges to examine the wide range of topics. Topic could be of any matter. Now come to As we have mentioned that this article is related to restructuring of the courts, so we will get to know what are the chronology when time and again such demand for restructuring is required. Here, when if we are discussing with the restructuring, then restructuring means dividing the Supreme Court's role be in one is the constitutional role and the second one is the appellate role. So here law commission in different cases has made their different observations. So first of all we need to know what is this Law Commission of India. Law Commission of India, it is a executive body, means it has been created by executive order of the government of India. It is meant to do the legal research and propose the legal reform to the government of India. It is an advisory body under Ministry of Law and Justice. Basically, this Law Commission of India are comprised by legal luminaries. They are appointed for a fixed tenure to propose the various legal reforms. If we see the history, the first Law Commission of India was constituted in 1834 under Charter Act of 1833 under the chairmanship of Lord Macaulay. On the recommendation of this Law Commission, the Indian Penal Code and Code of Criminal Procedures were codified. Now come to the recommendation of various law commission regarding the restructuring of the Supreme Court. The first recommendations came through this 10th Law Commission 1984, who proposed that the Supreme Court should be split into two divisions. The first one is the constitutional division and the second one is the legal division. The constitutional division will be exclusively dealing with the matters related to the constitution, means wherein the interpretation of the constitution is required, or any matter that requires the substantial question of law or fact, that would be dealt by the constitutional division. And the legal division particularly deals with non-constitutional issues, means the appellate matter. Now come to the 11th Law Commission 1988. This Law Commission further reiterated the demand of split of Supreme Court's role. It gives the reason why there should be such a split, means why there should be the appellate court on regional basis and why there should be the constitutional court at New Delhi. The establishment of the regional court will ensure the timely delivery of the justice, and it will also reduce the cost incurred by the litigant. Okay, and it also gave the analysis that if we analyze the appellate matters at the Supreme Court of India, the major proportion of the matter are related to the appeal coming from the high courts located at proximity of the apex court, compared to the cases the appeal coming from the high courts located at far away from the apex court. So if the proportion of appeal is less at further area, it shows that the people located at further area are hesitant to come to the Supreme Court of India due to some or other reasons. The major reason I have said that the cost incurred by the litigant in excess of the justice. Now come to this case, Bihar Legal Support versus Chief Justice of India 1986. Here the Supreme Court has made the observation that there should be National Court of Appeal to entertain the special leave petition and also the matters related to appeal coming from various high courts. And there would be a Supreme Court of India that would be only discussing and entertain the constitutional matters and the public law related question. Here the constitutional bench, that is the Supreme Court located in New Delhi, will discuss and deliberate the issues related to these cases on day-to-day basis. Now come to the further 229th Law Commission report, wherein the commission said that, recommended that there should be the establishment of the 4 regional benches in Delhi, Chennai or Hyderabad, Kolkata and Mumbai. These regional benches will exclusively deal with the non-constitutional cases. These regional benches will comprise by 6 judges from each region, will take up the appellate responsibility. Means this regional bench will discuss only the appellate matters. Okay, And the constitution bench that will be located in New Delhi will take up the cases related to the constitutional matter. If we see the colonial history, there are also 3 Supreme Courts located in different regions: Bombay, Calcutta and Madras, to ensure the widely available justice delivery system and for easy and less costly method of achieving the justice. The Indian High Courts Act of 1861, it replaced the name Supreme Courts with High Courts for these separate regional courts. The Government of India Act 1935 made the provision of Federal Court of India as an appellate body for Privy Council and the High Courts. Now, these were the discourses for the need of restructuring of the constitutional bench. Now, what is the benefit of such a split? It will ensure the greater judicial stability and consistency. How? Because there would be a clear-cut segregation. Means a particular divisional bench will take up the cases related to constitution, and particular segment will take up the cases for other appellate matters. It will also make the justice more widely available and accessible. With the establishment of National Court of Appeal at different regions will ensure the availability of the justice and accessibility to every strata of the society and the region across the India. It will significantly decrease the fees that litigants have to pay. As we all know that if justice is present at their doorstep, then definitely the cost incurred by them will be significantly reduced. So it will ensure the accessible and less costly justice delivery system to the every section of the society. So in this manner, if we see that this present the rationale behind the division, the restructuring of the Supreme Court, this is a high time to think about all these things. Although recently with the provision of going online by the Supreme Court has diluted such kind of demand, because now there is a online filing of the cases in the Supreme Court of India, and also the proceedings takes place virtually, means people located at a remote location now can attend the proceedings through the virtual, means video conferencing method. So such demand has been now being neglected, but again there is overlapping between the constitutional issues and non-constitutional issues, as we have seen the facts at the very beginning. Will give this demand and thinking that there should be restructuring, there should be a different division dealing to the constitutional matters and dealing to the appellate matters. Now come to the next article that talks about workers' debt in different work related hazards, okay, and the international labor organizations. Here this particular article is important because it is overlapping with the syllabus of GS2, that is social justice issue related to the development and management of the social sector. So here workers are one of the part of our society, and the other topic is important international and international institutions and their mandate, and also GS3 syllabus wherein disaster and its managements are mentioned. In this article we will get to know that how these workers debt in work related hazards are growing, and it is high time to think about their safety and health at workplace. Recently, in the recent incident, just like Uttarkasi tunnel collapse incident, wherein 41 workers are fighting for their life, and there are other incidents, for example the sand mining accident of the Rajasthan, wherein 4 workers was killed. And recently there were one more accident in Chhattisgarh due to the blast of the cylinder in cement power plant, plant industry. There were 4 workers are also killed. So it raised the demand for looking into the organizational safety and health of worker at workplace. Now the context here is that recently 23rd World Congress on Safety and Health has begun on November 27 at Sydney, Australia. It is one of the largest international conferences happening on this topic, safety and health at workplace. Here, International Labour Organization put a report titled A Call for Safer and Healthier Work Environment. In this report, ILA has made a different observation, different factual information and case studies related to the workers' death associated with work-related hazards. As per the International Labour Organization's report, nearly 30 lakh workers die every year globally. 30 lakh workers die every year globally due to the work-related accident and work-related diseases. Out of these 30 lakh deaths, more than 63% are associated with the Asia-Pacific region. Now you can understand this gravity of the workers' death and time to pay the attention. Now, the major reasons for such casualties are exposure to long working hours. Long working hours means the work hour over 55 hours per week. Due to long working hours, workers get fatigued and they become mentally and physically unfit to work in a proper manner. So this is one of the major reason for workers' casualties. Then the next important reason for workers' casualties are exposure to occupational particulate matter, gases and fumes. These lead to various diseases associated with work-related factors. Then the third important factor responsible for worker death goes to the occupational injuries. It could be the collapse of the slab, mining slab, or landslide, or debris, or any other things. Now, come to this chart where a different kind of work-related factors are given and also which one is major responsible for the death of the worker is also mentioned here. If we see this chart, this long working hours is the major responsible factor for workers' death. It alone causing death for 7.45 lakh workers' death annually. Thereafter, particulate matters, gases and fumes are responsible for death of over 4.5 lakh workers. Then comes to the injury, then asbestos, silica, asthmagens, UV radiations, diesel engine exhaust, arsenic and nickel. So out of these, we have to consider this initial four: long working hours, particulate matters, injuries, asbestos. These are very essential to look for to reduce such kind of casualties. If we see the sectors, then mining and quarrying sectors are most prone to this work-related hazards. Thereafter the construction, then the utilities sectors. Now we need to look the international labor organizations and the India. If we see the International Labour Organization, it is the only tripartite United Nations agency because it brings the three stakeholders, the major stakeholder, the government, the employer and employee in a single platform to deliberate on the labor standards, frame the policies and ensure the safe and healthy work environment for the working of the men and women. If we see the convention, the two important conventions on the basis of which this 23rd World Congress has been commenced there, the two important conventions are Convention number 155 and Convention number 187. This Convention number 155 is also known as ILO Convention, Conventional Safety and Health Convention 1981. It was ratified by 79 out of 187 countries. The second convention is the Promotional Framework for Occupational Safety and Health Convention 2006. It was ratified by 62 countries out of 187 member countries. It is important to note that India has not ratified these two conventions. Okay. Now, core principle of these two conventions is that to make a sound and resilient framework related to the occupational safety and health at work. It is important to note that this kind of framework should be framed by using proper social dialogue and the participation of all stakeholders. As we know that this two important convention has not been ratified, so there is a growing demand of the Central Trade Union to the Union Government of India to ratify such kind of convention, because now the incidence of such kind of occupational hazards are rising. The other two important conventions are the minimum age convention 1973 and the worst form of child labor convention 1990. This is also known as convention number 138 and convention number 182. These both conventions are related to the child labor, and the good thing is that India has ratified these two conventions. Okay, as I told you that International Labour Organization is the tripartite agency. The few more fact about it is that it received a Nobel Peace Prize in 1969. It was established in 1919 by the Treaty of Versailles and affiliated with the League of Nations. It was first affiliated specialized agency of the UN in 1946. India is one of the member of this organization. And currently it has 187 member countries. Now come to the various detail of the ILA report regarding the workers' death. If we consider the various type of death, the type of nature that cause the workers' death are the work-related diseases. The work-related diseases has a major cause of concern because it is causing more death compared to the accident, the work-related accident. If we see the data, 26 lakh workers die due to the work-related diseases alone compared to the accident. So, if we see these diseases has this major proportion related to the circulatory diseases, the malignant neoplasm and the respiratory diseases. These are important diseases responsible for work-related disease causing for death of the worker. Now, if we see the trend, then deaths due to these diseases, these facts are also important for your prelims point of view. It could be asked in your science and technology that trachea, bronchus and lung cancers due to chromium exposures. These trachea, bronchus and lung cancers are caused by the chromium exposure has doubled in 2000 to 2016. Now mesothelioma, this is caused by the exposure of the asbestos, has also risen by the 40%. Non-melanoma skin cancer has increased by over 37% between 2000 to 2020. So, for your prelims point of view, it is important to note that which disease is responsible for the exposure of which particular metal. So, these diseases are responsible due to the exposure of chromium. Mesothelioma is is associated with the exposure of asbestos, and non-thalassemia is also related to various other heavy metals. Now, if we see the fraction of death caused by the work-related factors compared to other overall death, the proportion of death causing due to the work-related death is very high in Africa, that is 7.39%, and followed by Asia and the Pacific, that is 7.13%, and the Oceania. This shows the proportion of work-related death out of other deaths. Now, here are some way forward suggested by the report. The 5 categories of the fundamental principles and rights that we need to look for ensuring the workers' safety and health at workplace. These are, we need to look for freedom of association and the effective recognition of right to collective bargaining. If we look the article of our Indian Constitution, one of the fundamental right under Article 19, Clause 1, Subclause C talks about the freedom of association has a kind of legal obligation over the union government to ensure the freedom of association and recognition of their collective bargaining power. Now, the second important one is the elimination of all forms of the forced or compulsory labor. If we look the fundamental rights under Article 23 that talks about the prohibition of child labor, the prohibition of forced labor as well as human trafficking. So, in one way, it is our fundamental right to ensure that there should not be any kind of forced labor or compulsory labor. Similarly, if we see the DPSP under Article 42, 43 and 43A, this talks to ensure the just and human work environment for men and women. So, this provision makes state legally obliged to frame such policies. There is the abolition of child labor. Article 24 of our fundamental talks about the prohibition of child labor in various factories. So, it is being already implemented by the Indian government, and it is also being ratified by the Government of India in 2017, and also framed the Child Labor Prohibition and Regulation Amendment Act 2016, wherein the rules dealing with the child labor has made more stricter and penalty has been increased. The fourth one talks about the elimination of discrimination in respect of employment and occupation. And the fifth one talk about a safe and healthy working environment. So this is very crucial suggestion made by International Labour Organization to ensure the workers' safety and health at workplace, so that there should be a holistic development to every section of the society. Okay, thank you.